we have instructions for post pay, instructions from our client, the Director of Public Prosecutions. And as regards Mr. Njeri, Mr. Njeri's request for directions, we believe that because we are post pay and bail being ordinarily a right, then it has to go first in an application to post pay. They'll have a chance to respond to our application. That's agreeable, they can go on our arguments. My learned senior, Mr. Akula, will take the court through the affidavit, the functional matrix. Allow me to take the court through the legal matrix. Now, I'll start by indicating that the law on bail is almost settled. Sorry, Your Honor.
Slow is
All right.
recording.
My apologies. My apologies. I come from the lakeside. I speak
Synonymous.
Your Honor, our application in Thank you. You know, like I was indicating, the law on bail and bond in Kenya is settled, or almost settled, if not settled. And our arguments are founded on Article 59(1)(h) of the Constitution. Article 50, there, sections
159,
sorry, Article 49(1)(h)
49, 1,
of the Constitution. 50, there, section 123 and 123 capital A of the Criminal Procedure Code. And of course, section 8 of the Magistrates Court Act, which gives this court jurisdiction to entertain this matter this morning. You know, it is the import of Article 49(1)(h) that bail is a constitutional right, and that every arrested person or an accused person has entitlement to bail unless there are compelling reasons to deny bail. Now, we submit to you, and we believe that at the tail end of our submissions on the prosecution side, we shall have established at least 3 compelling reasons. At least 3, there could be more, to justify this court's denial of bail for the accused person before you. And then just to emphasize, the import of Article 59(1)(h) is that while bail is a constitutional right which should ordinarily be granted, where such compelling reasons are established, the court must deny bail. You know, that you do not have a discretion. Where we establish compelling reasons, you cannot exercise any discretion. You must deny bail. And Your Honor, just on the question, so, Your Honor, unfortunately, I'm not able to read the court's pen. I'm short as well. But the court could guide me when I'm able to proceed. I appreciate that.
every sentence was.
Thank you. You know, that further on the question of discretion, the discretion that the court has on the question of bail then arises where the court has dismissed all the compelling reasons and is to set terms and conditions of bail. That therefore, Your Honor, where there are compelling reasons, as is our submission, then the court cannot grant bail, and therefore the court does not have to get to the discretion of setting terms or conditions of bail. You know, because I have had the benefit of appearing in the number of counsel for the defense in this matter, I can preempt what they are likely to tell you. That the right to bail is also, I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give them a chance to state what they are.
I am allowed to preempt and give
The
arguments.
defense has the capacity, Your Honor, and we will not want the counsel to belabor, to just speak for the state which it
A minute.
represents. The accused has sufficient
A
defense.
minute. Decorum. Decorum. I repeat, for the third time, decorum. Mr. Whitty, I give directions, give the defense time to state what they have to state. State what you have to state.
That's right.
Very well.
You know, there is the question of the relationship between the right to bail and the presumption of innocence. You know, it is straight law.
Pause.
of It is straight law that the denial of bail, where there are compelling reasons, is not a breach of the presumption of innocence. You know, I trust the court to have a look at the Chomley case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this was an notice there, the Chomley case is clear on the relationship between the right to bail and sorry?
At the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right of presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of a right under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with 7 decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes, as compelling reasons, the likelihood of interference with witnesses, likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an accused person shall be present for trial. But there is the secondary corollary purpose of bond, which is to protect the integrity of the trial before you. Protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. Where releasing an accused person on bail, even when it is shown that they will attend trial, where releasing them on bail will prejudice the trial and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. And Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights, or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Kulu.
Sworn on 19 May 2025 by Mr. Robert
Sworn on
19th of May 2025 this morning. Yesterday morning. Trial this morning. Yes. It is sworn by Robert Horner. Robert Horner. And Eacc forensic examiner. There are the factual reasons or grounds to take bail agreed upon in paragraph 1, paragraph 2, however. I will cluster them into
paragraphs
three,
1
1 to paragraph 12. However, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person through his agents, the accused person through his agents attacked Eacc and LPS officers in lawful exercise of their duties. Now this has been reported and is captured under annexure number R38. Kitale Police Station. R38. PR38. Annexure PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection, Your Honor, is founded on section 106B of the Evidence Act.
That is your name.
Who is obtained counsel for first accused. Section 106.
Based on
Section 106B
electronic evidence.
for electronic evidence.
You'll get your time.
No, I'm not raising an objection because it's my required to use.
You get your time, get it.
Possible. We have a next
I want to confuse the direction for us.
Yes, sir. We have next a series of photographs marked as RR1 to RR37.
1, 2, R.
37. Your Honor, those photographs depict vehicles belonging to Eacc, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the lawful unit.
Executing.
Their lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again, miscellaneous application number
E716
E716.
of 2025. That is stapled in paragraph number 4. Now, photographs RR3 to RR10. RR3 to RR10. They depict the motor vehicle KCH 046T.
Come again, 0.
46T. After it had been balanced. There are photographs R11 and 12 depict KCD 62HX after the balance. Photograph R11 KBU 7.41. And photographs for RR14 to RR26 depict the motor vehicle KCF 541 U. KCF 541 U. Run at paragraph 7 and paragraph 8. The officer depots.
Sorry?
Paragraph 7 and paragraph 8. Mr. Ronald depots that after vandalizing these vehicles, important documents were taken. Now you take judicial notice of the position of the first case. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. Now, what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is with the witnesses.
The test is
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, and I'm aware of the directions you have given about the paper. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are the subordinates of the government.
give the guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm on the
But let me report you first. Mr. Akuma, give me some time. I need to record this projection. Everyone, I need to
I will
continue.
repeat your order.
How long more? I thought we were going to take 3 minutes. Now we are going, we'll be sitting here the whole day. Just off the cuff. How long more?
I'll take it, clear it. Just summarize it.
10 minutes. Continue, Mr. Fu.
Yes, sir. I will repeat
So
that
your 10 minutes.
we are submitting that once disclosure is done, the witnesses will be calling officers from the first of this time. Those are this information. I got the second link. It's a very important offense.
Sorry?
I got the second compelling reason. When appraisal of the child, the amounts will appear caution.
The amounts will appear.
Minimum,
Minimum.
1 million. I should believe Your Honor will win this case. And will draw your attention to section 62, 1. Over 7. 62, 1 over 7. In the event we succeed, that provision is very punitive.
In the event,
We succeed,
we is
the
the
DPP
DPP.
prosecutes this case, we get a conviction.
This success.
Yes. We will be moving to section 62, subsection 1. And on that, the severity of corruption cases. Will it be a recipe for someone to interfere? We submit in the positive. Your Honor. Lastly, public safety. I've alluded, Your Honor, to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes, that our obligations now, and at least for the court to have an independent opinion, a plea bail report be available. A plea bail report be available before this court can decide.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank you.
How many of you would like to plead this way?
I'll take the first one.
Because I listed, how many? Listed 11.
Yes, and one, not all of us, not all of us.
So how many? Just to manage our expectations.
Not five. Not five for activity. We do for drama. You know, drama, we just want to do it for meetings. Because the issues are straightforward, you know. Okay, let me start by introducing Senior Counsel John Greenwa. He's our client. So we have an opportunity. Then I will do it. I will do this also, yeah? So,
That is
I will do it.
all.
Let me be the first one to just
I
answer.
don't need to record them.
Your Honor, let me on the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point will be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes. So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel who has now practiced for 33 years, I get concerned
For how long is that?
33 years.
That is not for intimidation.
It is fun. It is fun. When we
But I'm sure Dr. Camilo is smiling at you.
actually it's a sign.
Very sad.
Your Honor, when prosecution purports to teach this court the law, citing authority, citing sections, pointed out to deny an accused. Before I stand here and fast about it, I'm certain they do not believe in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice. We plead that Senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us.
Thank you.
Let us have mercy on the first
Maybe
case.
Mr. Jenny want to record special greeting, Mr. Njero. I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My key is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now is used to harass opponents. That's wrong, and we shouldn't allow it. Your Honor, I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been in private practice. One of the few. And I know how things operate in those agencies. I was the first year of independent police oversight authority, and there's a lot of running in the executive. Constant interference attempts to direct us on how to do our work, including by the current president when he was deputy president. And this is factual. It's in public domain, it is known.
Mr. Njero,
I'll give the context. I'll give the context. Your Honor.
the focus.
Yes, I'll give the context.
Focus here, Mr. Njero.
I'll give the context.